This is Juris Stupidity, a video podcast on the use and misuse of legal terms and concepts in social and other media. This episode is on contempt. The topic of contempt is sufficiently complicated so as to cause all sorts of possible misuse. For this reason, I am splitting the topic into two episodes. The first episode is devoted to contempt of Congress. The reason I have chosen this particular topic first is that a Trump administration official was very recently imprisoned for 4 months after being convicted of contempt of Congress for failing to testify before a congressional committee, while yet another Trump administration official has been sentenced to prison for the same offense, but has not yet begun his sentence pending the outcome of an appeal. It's very topical today. These officials' contempt convictions were one of 3 types of congressional contempt enforcement. Those 3 types are 1. Criminal contempt, 2. Civil contempt, and 3. Contempt under inherent congressional power. Criminal contempt of Congress is set by statute, that is 2 U.S. Code Section 192. This federal statute empowers prosecution against every person called as a witness to either House of Congress who, quote, willfully makes default or who, having appeared, refuses to answer any question shall be deemed guilty of a misdemeanor, end of quote, punishable by fine and imprisonment. This comes into play if the Department of Justice or the U.S. Attorney's Office agrees to prosecute a claim. However, if neither the DOJ or the U.S. Attorney's Office declines to prosecute and the claim arises from a U.S. Senate inquiry, then a second type, civil contempt of Congress, comes into play. In this second type, appointed Senate counsel sues for civil enforcement under 2 U.S. Code Section 288D. The third type of contempt enforcement has been rarely used, and this type of contempt arises from what has been interpreted as the inherent contempt power, which has been inferred by the courts as derived from the legislative powers granted to Congress by the United States Constitution. Under this power, Congress can direct its sergeant of arms to arrest the non-compliant target of a subpoena and detain the person until he or she complies with the subpoena or until the end of the congressional session. This form of contempt enforcement is so rare that the last time it was exercised was in 1935 in the case Journey v. McCracken, 294 U.S. 125, in which the Supreme Court ruled that Congress had acted constitutionally to use this power. Though this form of contempt is rarely exercised, it has been recently considered as an avenue to enforce persons to testify before Congress. For example, Congresspersons Ted Lieu, David Ciccolini, Val Demings, and Jamie Raskin, and Joe Neguse called for its use to enforce subpoenas in a congressional investigation. I bet you can now see how commentators can easily mess this topic up.